Welcome to The Explainer. Every single day, we're all making deals without even realizing the incredibly complex machinery operating right there in the background. Whether you're clicking accept on a software update, hiring a contractor, or enrolling in classes, you are participating in a legally binding dance. Contracts are, quite literally, the DNA of business. Today, we're going to anchor our lesson on a real-world scenario, a Canadian small business purchasing inventory. We're going to dissect the anatomy of that deal to understand exactly what makes it tick, how courts actually interpret the language, and what catastrophic defects can cause the whole thing to just completely collapse.
Think of this as our roadmap for today. We're covering Chapter 1, the foundation of contracts, Chapter 2, anatomy of contract terms, Chapter 3, crucial business contract clauses, Chapter 4, deciphering contract interpretation, Chapter 5, fatal defects in contracts, and finally, Chapter 6, remedies for contract disputes.
Let's jump right in. Chapter 1, the foundation of contracts. It's really vital to understand that a contract is so much more than just a piece of paper with some signatures scribbled at the bottom. It's actually a legally enforceable mechanism that creates rights, duties, and real expectations between people. Think of it as the invisible scaffolding of business. It keeps operations running smoothly and makes the future predictable. Let's start building our deal with this incredibly common real-world example. Imagine our Canadian small business is ordering inventory. They write up a document containing this one simple sentence: 500 chairs will be delivered for $20,000. That single sentence forms the absolute core of a legally binding commercial agreement. It establishes exactly what each party has to do and what each party is going to get. It creates a stable environment. Our Canadian buyer knows they'll have somewhere for their customers to sit, and the seller knows they'll be able to make payroll. Moving on to Chapter 2, anatomy of contract terms. Now, to make that broad agreement actually actionable, we have to break it down into specific promises. In contract law, these are known as express terms, and they are the beating heart of the agreement. These are the directly written or spoken elements that leave absolutely no guesswork about what each party is obligated to do. So our Canadian small business and their supplier have explicitly agreed on a price of $20,000, a delivery date of June 15th, and a precise quantity of 500 chairs. Express terms are the clearest part of the contract, simply because they are intentionally articulated by both sides. But here's the catch. The law doesn't just stop at what's written on the page. Under Canadian law, we also have what are called implied terms. Even if it's not explicitly written down in our document, our 500 chairs must, actually function as chairs. The law automatically implies that goods sold by a business have to be reasonably fit for their intended purpose and of acceptable quality. If those chairs arrive and immediately collapse the second someone sits on them, the supplier has breached the contract through an implied term. And that's true even if the phrase "must hold human weight" was never actually typed into the document. Custom and everyday industry practice can also create these implied expectations. And keep in mind, not all promises are created equal. This brings us to the binary nature of how we classify these terms based on their severity. First, we have conditions. These are major, essential terms. If you breach a condition, like, say, a wedding photographer just completely failing to show up on the wedding day, the main purpose of the contract is totally destroyed. In that case, the innocent party can completely terminate the deal and sue. On the flip side, we have warranties. These are minor terms. If you buy a brand new car and it's delivered with a few minor scratches on the door, well, you can claim financial damages to fix the paint, but you generally can't just cancel the entire car purchase. So breach a condition, the contract is dead. Breach a warranty, the deal survives, but with some compensation. Chapter 3, crucial business contract clauses. Good contracts use specific rules, we call them clauses, to proactively manage risk and clarify obligations long before a problem ever pops up. Take the delivery clause, for example. By explicitly stating that goods must be delivered to a specific Calgary warehouse by August 1st, businesses drastically reduce their legal risks. Other absolutely crucial clauses include payment clauses, which detail exactly when and how that $20,000 is getting paid, and termination clauses, which outline exactly how the parties can walk away from the agreement. You might also see a force majeure clause. That's a fancy term for protecting parties from unforeseeable extreme events like natural disasters or pandemics. And there are limitation of liability clauses that cap financial exposure. By layering all these specific clauses, our Canadian business is essentially building a protective fortress around its transaction. Chapter 4, deciphering contract interpretation. But what happens when that meticulously drafted fortress actually gets tested? What happens when a conflict arises and our contract goes sideways?
In the business world, disputes often happen not because a contract is missing, but from total confusion over what the existing agreement actually means. Imagine our chair contract simply said, fast delivery required. When vagueness sneaks in like that, we get ambiguous terms that cause massive disputes. What does fast actually mean to our Canadian buyer versus the supplier? Are we talking 24 hours, 3 days, a full week? Ambiguous language creates legal uncertainty. And when the parties lock horns over these vague terms, a court has to step in and decipher what their true original intention really was. So the really crucial point here is that judges don't just guess. They follow a very strict step-by-step methodology to interpret the mess. First up, they apply the plain meaning rule. That means looking at the ordinary, everyday dictionary definition. If a term says 7 days, they're going to assume calendar days. Second, they apply the whole contract rule, making sure one single clause isn't being read completely in isolation. Third, they look for the intention of the parties. They'll dig into past emails, negotiations, and industry customs. Finally, if it's still hopelessly vague, they use a rule called contra pro forentum. Basically, the ambiguous term is interpreted strictly against the party who originally drafted the contract. It's an incredibly powerful tool meant to protect weaker parties from sneaky, overly complex drafting by larger corporations.
Chapter 5: Fatal Defects in Contracts. Sometimes that isn't just about confusing words. Sometimes there are underlying fatal defects baked right in that can completely invalidate our contract from the very start. We're talking about turning a solid agreement into a complete legal nightmare. First, we have misrepresentation, where one party provides false information, like deliberately hiding serious property defects just to convince the other person to sign. Then we have duress, meaning someone was literally forced into the deal via blackmail or severe economic pressure. There's also undue influence. This is where a power imbalance, like a caregiver inappropriately pressuring an elderly patient, taints the whole agreement. And of course, illegality. Courts are never, ever going to enforce a contract that involves fraud, drug trafficking, or illegal gambling. Mistakes are another massive defect, particularly something we call a unilateral mistake. Picture this. Our Canadian business intended to sell a premium set of goods for $5,000, but somebody makes a typo in the final contract and lists it as $500. The buyer sees the typo, secretly knows for a fact it's a mistake, and rushes to sign it just to lock in that ridiculously low price. Well, contract law actually recognizes this defect. When one party is mistaken and the other party knows it and tries to take advantage, the courts can actually step in and intervene. Now, depending on the specific defect we just discussed, the contract's legal status changes dramatically into one of these 3 categories. A contract can be void, meaning it has absolutely no legal effect from the very beginning. It was dead on arrival, kind of like an illegal gambling debt. Or it can be voidable, meaning the innocent victim, say the person who signed under duress, or maybe a minor who lacks legal capacity, has the powerful option to either cancel the contract entirely or keep it going if they want to. Finally, it might just be unenforceable. This is where the agreement exists, but it fails some strict technical requirement, like missing a legally required written signature. And that brings us to Chapter 6, Remedies for Contract Disputes. So if our Canadian small business gets wronged by one of these defects, or if those 500 chairs just simply never arrive, how do we actually fix it? What are the real legal remedies? Well, when a breach happens, courts step in to offer these specific solutions. The most common one by far is awarding damages. That's a financial payout to cover the innocent party's losses. If our business had to rush out and buy emergency replacement chairs for $25,000, they could sue the original supplier for that $5,000 difference. Another powerful remedy is rescission. This effectively unspools the contract, canceling it completely and returning both parties back to their original financial positions, basically acting as if the deal never happened. In rare cases involving highly unique items, like a specific piece of real estate, courts might order specific performance. That literally forces the breaching party to actually complete the delivery. Or a court might issue an injunction to legally prevent a party from taking a damaging action, like leaking confidential business secrets. So as we wrap up this deep dive, ask yourself, is your next business deal truly airtight? Are your express terms crystal clear? Have you protected yourself with the right clauses and safeguarded against those fatal defects? Because ultimately, a well-structured contract does so much more than just prepare you for litigation. It actively creates the trust necessary for our entire economy to function. The next time you click I agree or sign on the dotted line, remember the incredible, invisible machinery you just set into motion. Thank you so much for watching this explainer. Please remember to like the video and subscribe to the channel so you never miss out on our deep dives. Keep learning, keep structuring those deals, and I will see you in the next one.